Hang on a second
All right.
while the live streaming prepares itself.
We do have a little bit of time though, so
Hang on a second. Okay, while the live streaming prepares itself. Uh-oh, why am I hearing double?
Hmm.
we do have a little bit of time though, so you have to close YouTube. It's picking up the YouTube
I don't see a YouTube.
when you went to establish the
okay,
live
it's
stream.
closed. Yeah, it's closed now.
Yeah.
Ladies and gentlemen, we are now live streamed. This is Housing and Real Property Subcommittee. Today is March the 8th, and it is 5:22. I'm going to call this meeting to order, and we're going to start with HB 34. And Matthew, if you could give us a little bit of information on HB 34, that would be greatly appreciated.
Certainly. So the subcommittee may recall that HB 34 is a bill that generally requires the district court within 60 days after the final resolution of a failure to pay rent proceeding that did not result in a judgment of possession, and for which no appeal is pending, to seal all related court records. It would also authorize the court to seal all court records relating to failure to pay rent proceedings under certain circumstances. I'm going to go straight to the amendment because there are a number of changes. So the amendment number is House Bill 34-523-924-1. I just want to start out by saying this is a series of amendments provided by the sponsor that's intended to address the outstanding concerns on the bill and addresses the rent escrow concerns and what was included in the judicial conference testimony. So amendment number 1 is technical. Amendment number 2 is first bit in 8.1 new language, section 8.119 of the real property article would limit the application of the prohibition against increasing rent solely because a judgment was entered against a tenant in a failure to pay rent action. And the limitation is that this would not apply if the right to redemption is exhausted. So you'll see the two provisions related to right to redemption are referenced there. And actually, I'm going to bring the sponsor's amendment up on the screen now. Mr. Subcommittee Chair, could you make me a co-host?
Yeah.
Thank you.
As soon as you said that, there you go right there. Matthew, you are now co-host.
Okay.
Having trouble hearing you, Marvin, for some reason.
Oh, really?
Got a little distant.
Is anyone else having trouble hearing me?
Good.
You are. I don't know what to do.
We'll just have to listen real careful.
You sound far, Mr. Chair. You sound far.
He does. Or I do.
Maybe I could utilize the.
That's better.
That's much better.
Really, I moved further away.
Maybe it doesn't like you.
Won't be the first. Okay, go ahead, Matthew.
Sure. So the next bit would be on page 3 of 4 of the bill. And this is where it would alter certain standards under the bill to require a showing of good cause. Would also address outstanding escrow concerns and only shield court records related to the judgment for possession under a failure to pay rent case and not the records related to the escrow action, and then would apply the bill prospectively. So that's as I mentioned before, for those who are just joining, the sponsor's amendment. And again, the goals was to try to address as many of the concerns as possible from the various groups who were favorable with amendment or opposed to the bill.
And this does apply prospectively. Is that correct, Matthew?
Yes, the language here would apply prospectively.
Okay. All right. And it did strike the word sealing and now uses shielding. Is that correct, Matthew?
It did. And in conversation with the judicial conference, a lot of that comes down to what appears to be an administrative burden issue. Shielding or sealing would require going back to the original judge who issued the motion to seal to reopen a file if there were need be. It's practically very similar standard in terms of the protection it provides, but just administratively easier to implement.
Right. And the protection is, like you said, very similar to both. So the intent of the legislation is maintained. Okay. Are there any questions that anyone wants to ask about the amendments that Matthew just went through? Let me stop there. Are there any other amendments, Matthew?
No, this is the only amendment that was provided on the bill.
Okay, Delegate Boyce.
Thank you, Mr. Chair. So you mentioned, Mr. Chair and Matthew, that these amendments satisfied the concerns or the favorable with the amendments?
That's my understanding. There was, from talking with the sponsor, there was a good conversation, a good back and forth. And that was the sponsor's original amendment. And then there was some additional language provided by the judicial conference to the sponsor. But I believe the parties who were involved with that, at least, perhaps not the individuals from the judicial conference, but at least the parties who are involved in that discussion are on the call today and maybe can attest to that.
Can I ask them?
Absolutely.
Kathy Howard.
Matthew, can you do me a favor and remove your screen sharing that way I can see hands if hands are raised. Is there someone here that can address Delegate Boyce?
Can I ask Kathy Howard?
Yes.
Certainly.
Yes. Hi. Thank you, Delegate Boyce. Yes, we worked along with Public Justice and some of the other stakeholders to make sure that we had all of these to everybody's liking. The main concern of MMHA was to make sure that in a rent escrow case that what got shielded would be the information that came out of the failure to pay rent case, not the information that was part of the underpinnings of the rent escrow case. Because if you remember, I think we talked about this before, a rent escrow case can be started in two different ways. One is if there's an affirmative rent escrow that the tenant brings because there's a problem in the unit, but they can also do it in what they call a defensive rent escrow, which is if there's a failure to pay rent case for non-payment of rent started by the landlord, the tenant can defend themselves by coming into court and telling the court that there are problems in the unit and that's why they're withholding the rent as a defense. And then when that happens, the court notice and the rent escrow case sort of get, as I call it, married together. It's called just consolidating both cases, and they travel together until the end of the resolution of those two cases, and then they again separate, and there would be a failure to pay rent outcome, and then the rent escrow. So we were concerned that only the failure to pay rent part become part of the shielded part of the situation.
And that has been taken care of, is that correct?
That has been taken care of. I think it's very clear.
Thank
Okay.
you.
And can I ask of Mr. Turner of the Public Justice Center?
Absolutely. Mr. Turner?
Yes. I would echo Ms. Howard's assertion of the bill in that regard, and that we believe that's what the bill does as well.
Thank
And
you.
you are satisfied with the amendments?
Yes, Delegate.
Thank you, Mr. Chair. Thank you.
Yes, indeed. Yes, indeed. And thanks, Delegate Boyce, for asking the questions. Delegate Lehman, you have your hand up.
Yes, thank you, Mr. Chair. And I'm sorry I joined a few minutes late, so I hope I didn't miss this. Going down to the language around a court record that had been shielded being reopened. The second, paragraph 2 on order of the district court for good cause shown, and that's underlined. What exactly does that language mean in, non-legal terms? I assume that's a standard.
Where?
Yes.
Page 2, you said?
I have it up on the screen.
I'm sorry, it's page 3, but it's paragraph 2 on the copy. I'm looking at a hard copy, line 22, Mr. Subcommittee Chairman. On order of the district court, a shielded record can be opened for good cause shown.
Okay, Matthew has it on the screen now.
Mr. Chairman,
Yes, sir.
isn't this the language, the legal standard that was given to us by Judge Morrissey?
That is correct, yes. That's exactly correct. And Matthew, you want to expand upon that?
Yes, so generally, to my understanding, good cause shown is a finding of substantial reason or a legal excuse for why the court should take action.
Okay, I surmised that it was legal language. I'm not a lawyer, which is why I asked.
Yeah, and this
I was in the meeting with Judge Morrissey, and he was he wanted to use standards that were in common usage in the court. So that was a suggestion.
That's understandable. Thank you, Mr. Chair, and thank you for the clarification.
Yeah, we had a meeting on Saturday, and this was his suggestion.
Thank you.
Any additional questions on any of the amendments? Seeing none, I
Can I move the amendments, Mr. Chair?
Thank you, Delegate Boyce. Is there a second?
Second.
Is there any discussions on the amendments? Seeing none, anyone in opposition of the amendments, raise your hand digitally or seeing no opposition of the amendments pass. Can I get a motion on the bill as amended, please?
The bill is amended.
Second.
All right, fantastic. Is there any questions or discussion on the bill as amended? Seeing none, any opposition? I'm sorry, Matthew.
Yeah, Delegate Baker, we're on House Bill 34. I believe you
Yes,
asked
for some reason, the host just left me in. House Bill 34.
Yes, sir.
Yes, sir.
I'm sorry, Delegate Baker. I didn't see.
That's all right.
I didn't see you, Delegate Baker. I'm so sorry.
That's all right. I don't think I see myself either. That's a good thing.
So we are now on HB 34 as amended. I think we have a motion and I think we have a second. Any additional discussion on HB 34 as amended? Seeing no discussion, anyone in opposition of HB 34 as amended, raise your hand physically or digitally or just shout out. Seeing no opposition to HB 34, we're gonna have a favorable recommendation to the full committee on HB 34. Matthew, if I could ask you now to go to HB 98. And the first question I'm going to ask you, Matthew, is HB 98. We've been having some amendments floating around on HB 98. So the first question I'm going to ask you, Matthew, is are we ready to discuss HB 98 now?
So just to clarify, the subcommittee voted on HB 98
That's right.
with an amendment last Wednesday.
Yes.
In preparing the bill for full committee voting, I discovered an issue with the language and reached out to some of the stakeholders with some corrections and believe we're working through what those corrections are. Now, the corrections I don't think are substantive. I think they're technical and they really are meant to align with the intent of the bill as introduced, and generally to my understanding of the bill is introduced, and from what we heard in the hearing was that units, if they are detached in a condominium, should be under a certain insurance schema where you only are insuring the common elements with a master policy. And if you have attached units, you have your standard common elements policy, as well as the policy on the units bereft of any improvements that are made. And then it shouldn't change how funds are distributed, how funds are held, how funds are used to do repairs. So we're just trying to align the language with that. And I don't believe the amendments would force everything to come back to subcommittee, but I thought it would be appropriate to share that additional change with the subcommittee members and then present it at full committee voting.
Let me, for those that are new to the General Assembly and to the committee, the bill HB 98 is now in the possession of the full committee. But we're having the discussion now because there was a suggested amendment. There was an amendment that was technical that Matthew just discussed. And I wanted to have us, the Housing and Real Property Subcommittee, the opportunity to hear what that amendment was. But the bill in the process of the General Assembly is now in the possession of E&T, but I wanted us to hear what that amendment was. And we're going to be presenting that amendment in the full committee. Is that correct, Matthew?
I think that's the plan at this point, yes. And yes.
All right. Any questions on the amendment? And again, I just wanted to bring that to our attention just so that there isn't any surprises once we get to the full committee. Delegate Boyce, did you have a question? Great, fantastic. Therefore, ladies and gentlemen, we are now going to go to HB 105.
Okay. So I just to the subcommittee members and to the individuals who have joined us, my apologies for the 3 separate amendments. However, I wasn't sure exactly if they were consensus amendments. They were coming from various parties, so I wanted to keep everything physically separated. The amendment House Bill 105-343-729-1. This was the amendment we had discussed last week. It was my amendment about separating out the pre and post transfer meeting requirements just to make sure that there was no change to current law, but that the law as it would be amended to apply to a pre-transfer meeting in a condominium or housing, pre-transfer annual meeting in a condominium or housing association setting would be its own item.
Hang on one second, Matthew. Pull the bill up if you don't mind. And
sure.
That way we'll have a visual as you are discussing it. Thank you, sir.
Sure. Let me just let's see here. Okay.
Appreciate that, Matthew.
Absolutely. So with this bill and this particular amendment, I'm just going to show it for the condominium regimes, and then identical in intent language is used for homeowners associations. So as you can see, this just creates a physical separation between what happens pre and post transfer of the condominium or homeowners association from unit or lot owner, or from developer or declarant control to unit or lot owner control, respectively.
And that provision there has the declarant or the developer appoint 1 member onto the board. Continue, Matthew.
Not this particular language. This deals with the annual meeting requirement.
I'm sorry. Yeah, I'm sorry. You're correct. I'm sorry.
So currently, there's not a requirement to have 1 annual open meeting before transfer. So this would establish that
Sabrina,
one.
You got a minute?
To have 1 annual open meeting at which the agenda is open any matter relating to the condominium, and unit owners have an opportunity to provide comment. That would be organized by the board of directors or the developer or declarant.
Exactly. Thank you, Matthew. Continue.
Sure. So that's it for the amendment we discussed last time. The other 2 amendments, and I will start with HB 105-223-127-1. And let me just pull that up. Okay, so that language, I apologize for the scrolling, I know it can be disorienting. So there's been a question for several years on this bill about how to calculate when 25% of the units or lots have been sold and what that trigger would be for adding a single, at least one unaffiliated member to a board of directors of a condominium or homeowners association, or if no board was created, first establishing the board and then adding the one unaffiliated member. And in two separate conversations, as I understand it, both MBIA and the builders came up with language, MBIA specific to Condominium Act and CIA with language specific to the Homeowners Association Act. So I'm going to just talk about the Homeowners Association Act one first. This would require that on the date that 25% of the maximum number of lots currently planned, and first off, the Homeowners Association Act language would apply only when a development contains more than 12 lots. If the development contains 12 lots or less, calculating 25% is pretty simple. It's a simple matter. But the addition of the member would apply when there's 25% of the maximum number of lots currently planned or permitted that may be contained within the development have been conveyed to members of the public for residential purposes. And then this adds a provision that elaborates on how that would be calculated, how that 25% would be calculated. So it would be calculated based on the information to be supplied by the vendor under section 11B 105B3I of the Homeowners Association Act.
And
that,
if I could expand upon that for just a minute, Matthew, there was a lot of discussion about how to calculate when that 25% mark would hit in an HOA. Less of a controversy in a condominium, but a lot of discussion based upon an HOA because the two entities are developed differently. And that is why you see here in this provision of the HOA that we refer back to 11B 105B3(1), because that identifies how HOA is developed. And that's why we put that specifically in this language. I just want to make sure everyone understands where we got that from.
It specifically, it identifies at least one place where a vendor may disclose to a purchaser the maximum number of units that might be part of the homeowners association. So if you know the maximum, then you can calculate the 25% based on that.
Right. And Matthew, if you could, is there another amendment?
There is a separate amendment, and that's because this was one presented by the builders and with an inclusion by the sponsor. So let me open that one now and okay. So this particular amendment would actually have struck any reference to the provision with regard to homeowners associations. However, it would have specifically created a similar related standard for condominiums as to what we just discussed for homeowners associations, whereby the calculation of 25% of the votes in an expandable condominium would be that's subject to section 11-120 of this title. Would be based on the total number of units that may be subjected to the declaration upon full expansion of the condominium as identified in the declaration. So a declaration in an expandable condominium, one where you could develop it out in stages, would list the proposed maximum number of units, but would provide the developer some time period where they could effectively develop it in phases, and that would alter the voting rights. But you would know from the outset what the total number of units in that expandable condominium would be, akin to if it was just a simple condominium will only ever have 100 units.
And ladies and gentlemen, I just want to make it clear to all of you, the language that's in front of you now is specific to condominiums. The language that was in front of you previously are referencing HOAs. And that's why the language is a little bit different, because there's two separate acts. There's a condo act, and there's a HOA act. That's why the language is a little bit differently between the two. Now,
There is one more.
Go ahead.
Sorry, there is one more change, and that was so the members may recall some of the recommended amendments from the builders. One of those recommendations was to strike language related to the notice of bonds and the release of bonds. The sponsor had added language clarifying what it meant for delivery. Just to be clear, that it wouldn't be some sort of process service or anything, but simple first-class mail delivery to the unaffiliated member, I think is what was intended when the bill was originally drafted. So it clarifies the process, makes it something easy to comply with.
Thank you, Matthew. That's all the amendments, right?
That is all the amendments.
Well, let me put it this way. Those are all the amendments that the chair of HRP likes. Is that correct, Matthew? Yes.
Those are, yeah.
Okay, now, Matthew, what I'm going to do now, ladies and gentlemen, is I'm going to open up the floor to anyone to have any discussions about those amendments. If anyone wants to say anything, raise your hand digitally or physically, or if I can't see the hand, give me a shout out.
Talking about just the committee members or also the public? Mr. Chairman?
Right now, just committee members.
Okay.
So any committee members have any discussions or questions about the bills at this point? Okay, seeing none, I'm now going to go to the stakeholders. I see Mr. Hinton is chomping at the bits. Fire away, Mr. Hinton.
Okay, thank you very much, Mr. Chairman. I guess I had not had a chance to review the HOA language with the building industry and with the lawyers that we rely on, that I know you've talked to on several occasions, Mr. Chairman. I think when we talked with Matt over the end of last week, and I thought we talked with you, we were talking about putting the HOA language on hold, and I had not seen that language until just now, and I've not had a chance to discuss the HOA language at all with my client. And unfortunately, neither of the two lawyers that we work with all the time, Sheila Lynn or Michael Farber, could be on the call today. So I don't know what their position would be on that, and I don't know if we could hold the bill to get feedback from them. That would be my, we've worked well with everybody on this, and I just don't have any feedback on it. So I would respectfully ask that maybe the bill be held till we can get feedback, and I'll try to get it, to you tomorrow. As to the condominium language, that is the language that we suggested. We looked at that. We've heard from the lawyers on that, and they're fine with the condo language. They're fine with the earlier language in the bill. As to the bond, our position all along has been, we don't think that the homeowners association or the unit owners or the condo unit owners, they're not party to the bond. We've objected to that all along. I know you understand our objections to that, and if the bill moves without that change, we'll continue to not like it, but so be it. I'm glad to see that at least we specified how the notice would be delivered. As to the bonding language, we're just concerned that it's just going to the bonding companies will be inundated, or the governmental unit will be inundated with calls, and it'll hold up release of the bond. So those are our concerns. If I would respectfully ask if we could just be given 24 hours to get back to you, or at least wait until next week I think the only issue that we would really like to be able to review, I know where you are on the bond, would be on the HOA, to make sure that's amenable to the lawyers that we work with that specialize in representing these communities and the developers. Thank you.
Got you. Thank you, but I understand. Thank you, Mr. Hinton. This is what I want to do. Currently in the full committee, we still have the opportunity to hold a bill in the full committee. So what I'm going to ask the subcommittee to do, if the subcommittee feels that we've addressed most of all the questions, I'm going to ask that we move this bill, and we move this bill as amended. And if there's any questions, anyone wants to hold it in full committee, we do it that way.
Move favorable.
Second,
Move favorable on the amendments. Is there a second on the amendments?
second,
Second, any additional questions on the amendments? Hearing none, anyone in opposition of the amendments, raise your hand, or physically or digitally, or shout out. Hearing none, the amendments have passed. Now, is there a motion on the bill as amended?
Move favorable.
Thank you.
Second.
And there's a motion and a second on the bill as amended. Any discussion on the bill as amended? Hearing none, if there's any opposition on HB 105 as amended, raise your hand or gives us a shout out. I see no hands being raised, so HB 105 as amended will receive a favorable recommendation from the HRP. Let us now, Matthew, move to HB 150. And Matthew, if you could give us a little bit of discussion about HB 150, that would be fantastic. You're on mute, Matthew.
Sorry about that. The bill
Okay.
establishes that adaptive reuse of property to develop affordable multifamily housing is an eligible use of the proceeds of a loan for specified housing programs administered by the Department of Housing, Community Development, or DHCD, and would also require DHCD to notify applicants to those programs that adaptive reuse of property to develop affordable multifamily housing is an eligible use of loan proceeds. There were two amendments that were offered by the sponsor. The first one, I'll pull that up now, but I'm referring to HB 150, 143, 928-1. And this was an amendment offered by DHCD to
Matthew,
address one of its concerns that it brought up in the hearing.
Matthew, put that on the screen if you don't mind,
Yep.
sir. Thank
Yeah.
you, sir.
Okay, so the amendment would simply specify that this limits the notice provision or notice requirement in the bill to applicants for a loan under certain programs of DHCD if the program allows but does not primarily focus on housing development. So those would be those programs included within the Division of Neighborhood Revitalization. So what we heard from DHCD was that while some of the programs here have funds that could be used for this purpose, it's not treated as the highest or best use to use them for housing. Rather, they're really focused on developing surrounding communities and the area. So this would give DHCD that little bit of discretion to identify the kind of appropriate programs for funding housing and adaptive reuse for affordable multifamily housing.
And the other amendment, Matthew?
Sure. So the other amendment is House Bill 150, 703, 324-1. And I will pull that up just now.
Thank you, sir.
Okay. So in essence, this amendment would provide that adaptive reuse of existing buildings to create workforce seasonal housing would be an eligible use of certain financial assistance provided by DHCD. The amendment defines workforce seasonal housing as a dwelling reserved for individuals who have temporarily relocated due to short-term or seasonal employment in the hospitality, recreational, or leisure industries.
Ladies and gentlemen, what I'd like to, those are the only two amendments, correct, Matthew?
The only two amendments, and basically it just puts, the last one just puts workforce seasonal housing in the same position as affordable multifamily housing.
Fantastic. What I'm going to do now is open up the discussion to the members of the committee to discuss the amendments. Delegate Lehman.
Yes, Mr. Chairman, thank you. And thank you, Mr. Michler. I'm just curious where this workforce seasonal housing amendment language came from.
It came from the ENT historian, the sponsor of the bill.
The
Is that correct,
Delegate Stewart came up with this.
Matthew?
I mean, yeah, where is
I don't
there?
believe.
I'm just
Hey,
curious
hey,
where there's workforce seasonal housing in the state of Maryland besides Ocean City. I'm
Hang
just,
Mary, hang on a second, Mary. Let's let Matthew answer your first question first. So this is the amendment came from where, Matthew?
Well, I believe it was brought to the sponsor by a particular group. I'm not sure if they testified on the bill.
yeah, I don't
see
remember any testimony whatsoever about workforce seasonal housing. So it makes me curious about the genesis of it and what does it apply to? I know what workforce seasonal housing is. I'm not asking you the definition. I'm asking you what does someone have in mind with this amendment?
Based on the type of housing, I would imagine it's. I mean, I based on the type of housing that's described here, I could certainly see this being used in and around resort areas. Although it's not necessarily limited to that, it's for short-term or seasonal employment in hospitality, recreational, or leisure industries. So theoretically could apply statewide, although I think probably the greatest usage or the greatest clustering of it would be in resort areas.
Did you want to Mary? I'm sorry, Delegate Lehman.
Yeah, I just am not going to vote for the amendment without a better, Mr. Subcommittee Chair, I'm just saying I'm not voting for this amendment without a better explanation of where it came from. So it's fine. I'm just going to ask for a roll call vote or something so I can vote against the amendment.
Let me get my sentence out. If you'd like, because this is the first time we're hearing this in the subcommittee, we can hold this and you can ask the sponsor directly and we can bring it back up next week.
Then I will request a hold on it.
Delegate Boyce, you want to hang on to your question till next week or you want to ask it now?
I guess I was just wanted to make a comment that workforce housing doesn't necessarily, I would argue, not necessarily have to be for a certain area or region of the city. I'm wondering if it's a way to potentially create more affordable housing in areas where there's development of new tech industries or things like that. So it was just a thought to just think about it when I saw her workforce housing, but I'm happy that we're going to hold it to get clarification.
Not a problem whatsoever. This is the first time we're hearing this in the subcommittee, unlike the other bills. We're going to hold this and get further clarification from the sponsor. Let's go now, Matthew, to HB 151.
Certainly, I'm just making a quick note for myself on the last bill and HB 151. You may recall from last week when it was discussed is Delegate Wells' bill on notification of rent increases. We'll bring up her original amendment to start the well, actually, let me first bring up pardon me, ladies and gentlemen. Actually, let's first address, if you'll indulge me.
Take your time.
House Bill 151-613-222-1. This is not Delegate Wells' amendment, but an amendment by the chair of the committee. And
which I talked with Delegate Wells and she accepts the amendment.
mm-hmm.
Thank you, Mr. Chair.
So the HB 151-613-222 would add a new reporting requirement for a local government that adopts a local law to limit the rent increase a landlord may charge a current tenant for a subsequent term that occurs without a gap in tenancy. It would provide for the applicability of the section. In essence, the reports have a dual requirement. First, that the General Assembly is advised of the adoption of the local law. And this is really because DLS and the library need a way to track when these local laws come into being. And then the second notice requirement would be an annual report starting January 31st of the second year after adoption of the local law on the number of new building permits issued by local subdivision and local subdivision here would be a county or a municipality for multifamily dwellings intended to be used as rental properties. So you'd have to the reporting would require information 2 years prior to enactment and then during the time period since enactment. Subsequent reports would be treated as updates. And finally, the bill provides for interpretation of the section, or the amendment provides for interpretation of the new section created by the amendment.
And there are other amendments, correct, Matt?
There are other amendments.
Hang on a second, Matthew. I see Delegate Long's got a question about this particular amendment. Delegate Long?
I'm sorry, Mr. Sheriff. I was making sure we didn't miss the other amendments about the two options for
sure.
reporting. But I think you just said that we haven't got to the other amendments. So my apologies.
That's correct. That's okay.
So the sponsor of the amendment is here in case they say anything, but yeah.
Yeah, just very briefly, I noticed that quite a number of local jurisdictions, Montgomery County, Prince George's County, a municipality in Prince George's County, maybe some others are thinking of implementing rent regulation, which is legally allowed. They don't need approval from the state of Maryland in order to implement rent control. But I think as a matter of public policy, it makes a lot of sense for us to know whether or not it is having the effect of increasing, decreasing, or no effect on the amount of investment in the multi-housing industry, because I think that's important. What happened in Tacoma Park is they implemented rent control in 1981, and I believe there have been no net new apartment buildings built there since then. So, I see this as a disclosure. I know that this is an issue that we're going to have to deal with in the future. So rather than guessing as to whether rent regulation hurts or helps housing, I think we should have DHCD collect the information so that future legislatures can make an informed decision. And for that reason, I'd move favorable on that amendment. And I reiterate, I talked to Melissa Wells and she was completely fine with it.
And before
Second.
any discussion, I want to make sure that this is just one amendment, Matthew. Are there other amendments?
Yes, this is just one amendment. There is the sponsor's amendment on the bill, which addresses some of the concerns, which deals with the actual timing of the provision when notice is provided, and we'll get to that shortly.
All right, so we have a motion and a second discussion, and I see two hands raised in reference to the amendment. I'm going to let Mr. Hill in to discuss his concerns about the amendment.
Thank you, Delegate Holmes. The concern is that as I understand the amendment, is with the study of the housing permits piece. And if you're studying how many housing permits are issued in a local jurisdiction that has a rent stabilization law, you really need to study the housing permits in the local jurisdictions that don't have a rent stabilization law, so that you can have more of an apples to apples comparison as to what impact it might be having in a rent stabilization jurisdiction versus a non-rent stabilization jurisdiction, in my opinion. Otherwise, the data is not as useful.
Could I respond?
Yep, please, Mr. Chair.
Yeah, look, I'm not going to ask for data from local governments that are doing nothing to change the law. I think the way to learn whether something is being helpful or harmful is to focus our attention on the people who change that aspect of the law. And, it could be that the property owners are wrong. It could be that rent control doesn't affect the number of housing units that are built. And if that's the case, then, the advocates have a really strong argument for rent control.
Delegate Naraki.
I was just going to say that I agree with Mr. Chair. I don't agree that we need to study every jurisdiction in the state for whatever reason, and I would move the amendment as Mr. Chair has presented.
We have a motion and a second on the amendment. Any additional discussions? Hearing none, anyone that is in opposition of the amendment, raise your hand physically or digitally or grunt or something so I can hear you. Hearing no noises or hands, this one amendment passes. Now, Matthew, if you go to the other amendment, I'd appreciate it.
Yes, sir. So the other amendment would be House Bill 151-553-528-1, which I am pulling up now. And this amendment we had, or the subcommittee, I should say, had discussed last week, but just to do a quick run through of what it would do is it would limit the application only to those landlords who have not provided a notice of intent to terminate a tenancy, would provide that the form of notice of a proposed rent increase would take place via first class mail with certificate of mailing, would strike the provision that would have limited the application of this notice to any time that a rent increased by more than 4%. So then now it's applicable to any rent increase. It could be 0.5%, it could be 10%. Just anytime rent's increasing, if you're not going to terminate the tenancy and you're going to increase rent, you have to provide notice. It would tie the notice provisions to the time a landlord would be required to provide a tenant with a notice of intent to terminate. So currently for a lease of 1 year, that would be 90 days. So at the 90-day mark, you're either saying, hey, tenancy has been terminated, or I guess you could say the tenancy is proceeding, but there's no rent increase, but you would have to provide notice if you're saying the tenancy is continuing and there would be a rent increase. And that is it. That is the amendment. Sorry, there's one more bit. It's not to interrupt, but it would provide that this section would not supersede any local law or ordinance that provides additional notice or additional protections.
Right, and that's just not to circumvent Montgomery County's law. And these notice provisions are consistent, as I recall, with existing provisions. Let's first go to. Let me first go to Ms. Howard. Unmute yourself.
Thank you, Mr. Chair. I appreciate that. Mr. Chair, there's Ms. Graziano, I think has also some points on these amendments. I also very late today, I just sent Matthew some additional language for these amendments that would have to do with concerns about electronic notification methods. And I would intended for them to be here a little earlier for everybody to take a look at, but unfortunately my day sort of got away from me. But I do think that there's been a lot of talk around the idea of having electronic portals or electronic communications between a landlord and tenant around these rent increases. It is a very good thing. A lot of people are using this kind of electronic communication with their tenants, and so I think that we have to make sure we address that in this bill. It does not have to be a mandatory thing, and I know that there's some concern that it would be made hidden in the lease or something along those lines. But I think that we've addressed that in the amendments that I just sent to you, and I'll let Lauren talk a little bit about what has already been sent to you all.
But how would this? What if? Let me ask you a question. Is this enabling type of electronic notices, or what if someone doesn't have the means to accept electronic notices? How would this work?
The alternative in that situation would be it's basically it's either in writing by first class mail with a certificate of mailing, or by electronic notification method, including but not limited to email and online portals, which is mutually agreed upon in writing by the landlord and the tenant, and that will provide the landlord with proof of the transmission of the notice. That's where we are so far.
Matthew, go ahead, Matthew.
Just to individuals from MMHA on the call, would it be appropriate for me to put this language up now on screen? Okay,
Sure.
Is it in a finalized enough form where you were comfortable
Yes.
with it being shared? Okay.
Yes.
And I will do that
Great.
to help facilitate.
All right, so what I'm gonna, Matthew, while you're putting that up, Matthew, next thing I'm gonna do is I'm gonna go to Lauren, and then I'm gonna go back to the members of the Housing and Real Property Subcommittee. Matthew, Lauren, you have the floor.
Sure. Thank you, Mr. Chairman. I appreciate that. I don't want to confuse folks by moving on to a different issue before we have sufficiently addressed this one, because my.
Let's hang on then. Let's hang on then.
Yeah.
Let's take one. Let's
exactly
take
right.
one spot. Let's take one thing at a time.
Exactly.
Thank you, Lauren. All right, Matthew, pull that up if you don't mind.
Sure. Delegate Wells amendment, you mean? I'm assuming that's what is.
Yes,
what is
the
meant.
Delegate Wells amendment.
Okay.
And this is the amendment offered by the sponsor of the bill. Is that correct, Matthew?
Yes. Yes, this is the amendment offered by the sponsor of the bill without any additional information that was just being discussed.
Okay. And so now where in this, so this amendment does not talk about any electronic notices, does it?
No, the only notice that would be provided is first class mail.
That's correct. All right, so that is the sponsor's amendment that we're looking at right now. Is there anything do we have anything that shows what Ms. Howard was talking about, amendment that shows what Ms. Howard was talking about?
I had it up on the screen just a second ago. However, I apologize to the subcommittee. I just received it. So there was no real time to share it. Yes. I can pull it up on screen and that's the best.
If you would, that'd be great. Just so we can take a look at it.
And if I may just try to be helpful, I think if I recall correctly, last time we all agreed that there should be some kind of mechanism that allows for an opt-in of electronic notification. I think at this point, we're just working on refining the language and what that looks like.
And ladies and gentlemen, just to clarify, I believe this is addressing subsection B on page 1 of the bill. You might be looking at the reprint, but it's those lines 17 through 19. It looks to be a full rewrite of subsection B, at least in terms of the top notice provisions.
So it talks about in writing by first class mail with a certificate of mailing or electronic notification method, including but not limited to email and online portals, is mutually agreed upon in writing by the landlord and the tenant, and that would be provided. Provide the landlord with proof of the transmission notice. Has this been discussed with the sponsor? Do you know, Matthew?
I just received this. I'm not sure about any other. Okay.
Again, my apologies for doing this so last minute. That's not usually the way I try to do things, but it's been a little hectic around here.
All right.
We will certainly talk to the sponsor about that.
Let me go to the members of the Housing and Real Property Subcommittee. I'm going to go to Delegate Long, and then after Delegate Long, I'm going to go to Delegate Boyce, and then to Delegate Lehman. Delegate Long, you have the floor.
Thank you, Mr. Chair. I'm looking back from my notes from the last time we discussed this bill, and I have had some conversations with the sponsor of this offline. I'm recalling that the referencing notifications, there were supposed to be the two options, and there would be an opt-in option for the electronic, but the mail option was still to be sent out regardless, but the electronic would be opted in.
And that is consistent with the language that we just saw on the screen.
No, well, I don't think that was explicitly clear within one particular subsection. I know that he took it down, and I can get with you offline, but I'm having dialogue with some other members. I don't think that is explicitly clear.
I think this
Right.
is meant to be an either or, Mr. Chairman.
Yeah, it said, Delegate Long, if you look, can you see it? Matthew, expand it a little bit, make it a little bit larger. Thank you. Delegate Long, can you see that?
I didn't see the or. Thank you so much. I
Not a
apologize.
problem. Not a problem. So I think what's here in front of us, and Delegate Long, this is a question to you. Delegate Long, I think what is in front of us is consistent with your discussion with the sponsor. Do you think so?
Yes, now after reading it, yes.
Thank you very much, Delegate Long. Let me
Thank
go
you.
to, thank you, sir. Let me go to Delegate Boyce.
Thank you. And so thank you for this. And I'm glad that this is something the sponsor agreed upon, because we did, to Ms. Graziano's point, talked about an opt-in option.
Yes.
But I worry about, even with electronics, that there is no backup in case something doesn't happen. And so with the or, and even though it's in writing, I'd like to figure out how we discuss a backup, because even with the mail, even if it's, certified mail, it gets there. With electronics, if for some reason you don't get it or whatever, so I'm just wondering about another kind of security effort to ensure, if for some reason you opt in to an electronic option and then something happens and you don't get it one way or the other, how can we remedy that? And it's on both sides, right? As the tenant, I can say I didn't get anything from the landlord, and the landlord can say, this person has never communicated with me. So,
Right.
as we talked about this last week, we talked about how many property management companies now have online options for which the rent can be paid, and I'm wondering whether or not there's a communication hub within those as well. And if so, could we mention that as well? That way, all those bases are covered, because, so I just wanted to put that out there for thought. Thank you, Mr. Chair.
So just to follow up with that, Delegate Boyce, it sounds like you're suggesting what was on the screen previously with another option being a portal. Is that what I'm hearing you suggest?
What I'm suggesting is where it says mutually agreed on in writing, landlord and tenant, and it's email and online. So they would have to do both.
That is correct.
I think I'm fine. Thank you. I'm fine. Thank you.
That's what I wanted. Go ahead, Matthew.
Well, it's to be clear, it's an electronic notification method, including email and online portals. So those are two means by which you could have electronic notification, as I read it.
Right.
Illustrative example,
Got it.
not necessarily requiring an email and something through an online portal.
Got it. Thank
You
you.
good, Delegate Boyce? Delegate Boyce? Delegate Boyce, you okay? All right, I'm going to.
Wonderful. I'm great. I'm great. Thank you.
Not a problem. I'm going to go to Delegate Lehman.
Thank you, Mr. Chairman. And if Mr. Michael could bring that amendment language back up, so I'm referring to it specifically, and it's in front of everyone. So, yeah, I cannot support, and I don't believe in my conversations with the sponsor that she supports that or. It needs to be an and. It's not either in writing, by certified mail, or electronic, and I'm not going to get into email versus some other online portal. It is and, not or. That's not acceptable, and that is not what she is after. And so I really object to that. That or needs to be an and.
You said that the or is.
That's not okay to say that electronic should suffice.
All right, I just want to make sure, Delegate Lehman, that I understand what your objection is. Your objection.
Absolutely.
Hang on a second. Your objection is that or should be an and. Is that your objection?
Absolutely.
Thank you, ma'am. I just want to make sure. We don't
And that is what the sponsor supports.
I got you. I just want to make sure, that's all. Make sure I got you. Let me go now to, is there anyone, Matthew, could you eliminate or remove? Thank you so much. Let me go now to Delegate. Let me go to Delegate Baker.
Yes, I guess my question is, the landlord sends out, you all call it a certificate mail. I just call it certified mail or whatever it is, to where the tenant would have to sign acknowledging that he received. So what happens if he never goes and picks up the registered mail? Now, if I'm a tenant and I don't want to, and I know who that letter's from, I may not want to go there and sign for it. So just by sending the letter and the tenant doesn't sign for the letter, does that protect the landlord for the 90 days?
So,
Go ahead, Matthew.
well, I was just going to say, generally, there's a concept of the mailbox rule for notice. The fact that it's sent, and then there's a certain calculation based on the time it was sent. It's something I'd have to pull up to provide a clean answer to, but generally it's the mailbox rule. That would be sufficient.
I'm sorry, the mailbox what?
The mailbox rule. It's a standard for notice, so that you couldn't simply skirt, receipt.
So if the tenant does not sign to receive the letter,
Certificate of mailing. Sorry to interrupt. Certificate of mailing doesn't actually require a signature by the recipient.
okay, so it's just a certificate that the landlord has mailed it, and then there's I'm going to say 2 days. So 2 days later is when the official 90 days would officially be the starting date of the 90 days.
I don't want to say yes, because I personally I forget I forget the exact standard of the mailbox rule. One of the other attorneys on the call may be able to provide that insight. I'm going to try to find it now.
All right, let's do this. Delegate Baker, is there someone in one of the stakeholders can answer Delegate Baker's specific question at this point before we go into?
I think that there, I'll take a shot at that, and I think Zafar may also have some input on this. There's a difference between certified mail, with which the delegate seems to be talking about, and that is that it has to be signed. It has to be signed for by the tenant, and a certificate of mailing, which essentially is the sender of the mail. It goes to the post office, pays a little extra money, and with a list of all of the recipients of the mail that they're sending, and they get a certificate from the post office that this list of people were paid for and were sent the mail, or that the U.S. mail is sending those things along. It doesn't require any action on the recipient's part in order to get that mail. It just comes.
Okay, so I understand your explanation. Thank you. I've never heard of a certificate of mail. I've heard of certified mail. But so my question is, when will the 90 days for the landlord officially start? Is it from the postmark?
I would think that it would. I would think that the only thing that the landlord could demonstrate that it would be the postmark on the certificate of mailing. That's when it left him. And technically, the mailbox rule, as I recall it, is once it has left the sender's hands, it's deemed to be, or there's a the presumption that it's going to get to the recipient.
And that's generally what is coming back to me and what I am finding in my quick research that I'm able to do.
Are you good, Delegate Baker? Thank you, sir. All right, let me go now. Thank you, sir. All right, now let me go to some of the stakeholders. And first, I'm going to go to Lauren, then Mr. Hill, and then Mr. Zephyr Safar.
Yeah, Mr. Chairman, I just, again, want to try to be helpful. I think we're at a disadvantage here by virtue of the fact the sponsor herself is not here to give input firsthand. And I think it occurs to me, maybe we need to have a little more discussion on this language. The or is consistent with what we do currently within other areas of law, specifically around 10-day notices for late rent. This is an option we provide, and to the extent that we believe in creating law that's internally consistent with other body of law, I think this is worth further discussion.
Further discussion on which piece again?
On methods of notice, just methods of notice.
Mr. Chair,
yes, sir, Mr. Delegate.
I would resist us putting this off another week. Just wanted to put that on.
Me too. Okay. Anything else, Lauren, before I go? Thank you, Delegate Long. Anything else about?
Not on this issue. There's one other amendment I'd like to address, but we can finish our discussion here before I do so.
Yeah, let's finish this discussion first before I go into a different topic. Mr. Hill?
Thanks, Mr. Chair. Our concern too, and I told Lauren and Kathy and Matt this. I think Delegate Healy expressed this at the last subcommittee meeting, which is that if it is or, the problem is that a landlord's going to include this in their lease, their standard lease, and give it to the tenant, and the tenant is going to, the landlord will say, well, look, take it or leave it, right? You want to lease here, you need to agree to the terms of the lease. And that's a real problem for, particularly my clients who are older, may not rely on portals or email as much. And so we have a real concern with any sort of provision that allows a landlord to condition leasing on accepting of these electronic notices, especially when it comes to the leases that are signed now. Even with older folks, they're being told, look, you have to sign this on DocuSign. So get on DocuSign and click all the initials, and boom, you're done. And suddenly now they're getting all their notices through a portal. So that's a real concern unless there's explicit language that prohibits the landlord conditioning leasing upon accepting these electronic notices. And you'd also need something that allows a tenant to opt out at any time, because otherwise, again, we just worry about folks who are vulnerable getting trapped into these kind of things.
Mr. Zephyr Safar.
Thank you. I'll just co-sign everything Matt just said. It's really just a cautionary tale that in 2021, we passed a law that allowed a 10-day notice of intent to file a fair to pay rent case by electronic notice. And for many of our clients who do fall behind on rent, they're actually blocked from accessing the portal specifically because they haven't paid the rent. And so it just creates a cycle. But they
would still have access to their email though, wouldn't they?
Well, that just raises other digital divide issues that I'm sure all of you are very aware of. And just think of the person with that budget phone with a number that they've provided on their lease, and maybe they checked off a box that said that, yes, I would like to receive information from the landlord by text message. Their number changes, their email address changes, their access to electronic accounts comes and goes. So all of these things actually would just end up creating an unnecessary barrier to the notification that we're trying to establish within a specific time frame. So I just want to raise that cautionary note for you all. Thank you.
Let me go to Delegate Naraki and then Delegate Boyce.
Thank you, Mr. Chair. Actually, Mr. Shaw just kind of took where some of my thoughts in my head. I did want to check in. Once you said that, I want to give the industry a chance to kind of give their perspective on that 10-day notice, since we did just pass that just 2 days ago. Ms. Howard, we've talked a little bit about this. Could you kind of weigh in from the industry perspective, how that's worked on your side of things?
Yeah, the 10-day notice that has built into it options for how to deliver it. from certificate mail with certificate of mailing, as well as electronic mailing. And from what I can tell from everybody, we just started this, I guess, maybe 6 months ago when it was mandated. And to my knowledge, at this point, I know that regional management is doing it by certificate of mailing without any issues. And as far as our membership goes, the folks who are using portals have had success in getting these 10-day notices to the tenants. If you remember, that 10-day notice is essentially kind of a billing notice saying, hello there, you have not paid your rent yet. You've got 10 days to make sure that it gets paid before we're able to file a court notice. So that, if you remember that piece of legislation from last year.
Thank you, Ms. Howard.
And that 10-day notice is provided to the tenant how?
It can be provided, it has a number of options. First class mail with certificate of mailing, and then there are some electronic options, and that's there. I think I don't have it in front of me, so sort of those two things are what I remember the most.
It's pretty consistent with what we're discussing now, though. It sounds
right.
like.
Yes, and to Ms. Howard's point, Mr. Chairman, it is an or, not an and in that statute.
Okay. Let me go to
Mr. Chair, if I might, I do have it in front of me here, how it's provided, if that would be helpful.
Go ahead.
It says here, the written notice required under paragraph 1 of the subsection shall be in a form created by the Maryland Judiciary, and notice shall occur when the notice is sent by first class mail, certificate of mailing. That's number 1. Number 2, affixed to the door of the premises, or number 3, if elected by the tenant, sent by electronic delivery in at least one of the following forms. Number 1, an email message. Number 2, a text message. Or number 3, through an electronic tenant portal.
And do me a favor, Delegate Naraki. I don't have that in front of me either. If you could, there it is.
I
Right
just
there.
share. And I'm assuming we're referencing the language, particularly the failure to pay rent notice.
Yes,
Right.
Matt. Thank you. Sorry, that's what I'm looking at. Thank you.
All right. So
This is the language.
so the notice, it's where do I say? Judiciary notice occur. First class mail certificate of mailing affixed to the door of the premises, or if elected by the tenant, sent by electronic delivery in at least one of the following forms: email, text message, or through. That's, to me, ladies and gentlemen, seems like a pretty thorough methodology of notification. Now, to me, that sounds like a pretty thorough way of notification. Now, if that same language were applied to HB 151, that should certainly take care of just about everything, should it not? That's the question. It should not. Okay, Delegate Lehman, why wouldn't it?
Mr. Chairman, honestly, if the sponsor's, opinion even matters here, I think it does. Several of us have been in contact with her. She pointed out this has been discussed, the and versus or, and this is, as the housing advocate said, could become about conditioning a lease on the front end to tenants agreeing to electronic only. It is not, in my opinion, appropriate or fair. As one of the advocates said, we have a real digital divide in this state. In case folks forget that, we have regular, still today in 2023, efforts to address the digital divide and broadband access in various parts of the state. Not everyone is or wants to be contacted only by email or online portals or however else you want to think of it. And frankly, respectfully, I don't think looking at another bill instead of this bill is a very useful exercise right now. I really don't, respectfully. I'd like us to stay on this bill that's in front of this subcommittee right now. And I personally feel really strongly and have been in touch
Thank you
with
very much.
Delegate Wells, saying clearly that she prefers strongly that that be and not or.
I got you. That was not my question, but that's okay. Delegate Boyce.
Thank you. I was going to say earlier in the chat, I had spoken to the sponsor, and she does want, and I do believe, just because I'm going to play half and half here, is that currently I get my bills either by mail, and if I have been subjected to giving my email address, I get both until I decide that I want to opt out of, for instance, paper. There now I have online. I get I buy whether it's a text once I've paid something or online. And so I do want as the sponsor wants, but also an opt-out provision for the tenant, not in the lease, to say, should they want the notification, whether it's through a portal or an email, that they should be able to have it. But I think, to Delegate Lehman's point, the sponsor requested and I think we're supportive of the unless a tenant, not subject to the lease, but a tenant lets their landlord know that they want one or the other.
Gotcha. Any additional discussion? All right, this is what I'm going to do. I am going to notify the sponsor of this bill. And I'm going to notify the sponsor of this bill that she is to convene a meeting with all of the stakeholders, and that she is to come back to us next week with a resolution to the discussion we're having today.
Mr. Chair, with all due respect, apparently this has already been discussed and was discussed on the table. So
what is your suggestion, Delegate Boyce?
I'm suggesting that this is our committee and your committee, most importantly, and if it's the will of the body to add the language as the sponsor requested, then we can discuss that and move on
this one amendment. All right. I'll take that. I'll take that.
Motion.
There's a motion to remove the word or. I'm sorry, remove the word and put the word or in its place.
No, it's to remove or and add and. It's currently an or in the bill.
I'm sorry, I got it backward. I'm sorry,
Yes.
I got it backward. Yes, remove or and put in its place the word and. That is the motion on the floor.
I second it.
All right, any additional discussion on the motion on the floor? Motion on the floor is to remove or and put and. Any additional discussion on the floor? All right, all in opposition of removing or and replacing with and, raise your hand or let me know your opposition. That has been done. So that amendment has been added to this bill. We have other amendments to take up. Is that correct, Matthew?
So there's the sponsor's original amendment, which I actually don't recall whether or not the subcommittee has voted on. There was the chairman's amendment, which I believe that you voted on. However, you can always just do one general vote at the end to cover everything.
Right.
There was that language, which was absolutely just considered. And then I believe MMHA had a second proposed amendment, which I did not see listed in the copy that I just received or had put up on the screen. So we'd have to go to MMHA for that amendment.
So we've adopted two amendments thus far.
I can only affirmatively say one. Unfortunately, I must have missed marking the record. So what I would recommend is just having one vote at the end, and I will list out all of the individual amendments.
I thought we adopted the chair's amendment.
We adopted the chairman's.
Okay. So
we adopted the chair's amendment and we swapped out the word or for and. So we have those two amendments thus far.
Yes. So then the only thing that is affirmatively on the table is 553 528-1, which is the sponsor's amendment. However, again, I believe I heard Ms. Graziano with MMHA suggested there might be a second amendment that MMHA had. And I'm aware there was language that was being tossed around, but it was not included in.
Can we go over that particular, the sponsor's amendment? Or did we already go over it?
We discussed the sponsor's amendment and what it did. If there are any questions, I'm happy to answer the questions.
I'm happy to move the amendment.
Is there a second?
Second.
Any discussion on the amendment that we're discussing at this particular time?
Mr. Chair, yes, quick discuss. So this is MMH's amendment we're moving?
No,
Or
this is the
Sponsors.
sponsors.
Sponsor's amendment? Okay, got
Sponsor's
it.
amendment,
All
That's
right,
correct. Sponsor's
Okay.
amendment.
perfect.
All right.
Talking about this amendment right here, which is the sponsor's amendment.
In
553,
its
528,
entirety?
in its entirety.
Thank you, Mr. Chair, I'm good.
All right. We have a motion and a second on the amendment. Any additional discussion? All in favor, signify by, anyone in
Aye.
opposition of the amendment?
Yes, Mr. Chair, if I could just discuss, there's one clause at the very end. I hate to be a stickler, but I would like to discuss the non-preemption clause at the end, if I may.
None.
Can we finish adopting the amendment?
We did.
Well,
Yeah,
Did
We did? Okay.
Oh,
we had a motion and a second. Well, I'm
I
sorry.
don't recall.
No, I'm sorry. We did. I'm sorry, Delegate Boyce. We did not adopt the amendment thus far because Ms. Graziano had a question about the end of it.
well,
But,
Mr. Chairman,
Mr. Chairman, he's not a
We
part of
just
the
voted.
process.
We just voted.
Delegate Lehman, we adopted two amendments. We had a motion and a second on this particular amendment. We have not voted on this amendment yet, Delegate Lehman. Delegate, okay? Mr. Chairman?
yeah, I was just gonna say, we're in the middle of a vote. It's not really in keeping with our process to solicit support from non-members in the middle of a vote.
That's a good point, Mr. Chair. We have a motion and a second on the amendments before us. Anyone has any opposition to the amendments? Great, that amendment passes as well. We have three amendments before us right now. Can I have a motion on the bill?
Move the bill as
amended?
amended, Mr. Chair.
Is there a second? Any additional discussion on the bill as amended? Hearing none, we will have a favorable report on HB 151 as amended to the full committee. We're now going to go to HB 331.
Okay, so for HB 331, ladies and gentlemen, I did send out the amendments earlier to you. However, given that they were received late in the day, it was not time to prepare them for the full discussion at this meeting. I did want to send those out to the subcommittee members as well as the regular attendees to the meeting, just so that everybody could be reviewing them and come with any questions if it were discussed at a subsequent subcommittee meeting. That being said, I think it's probably an appropriate time just to mention that next week is the week before crossover. Usually there's a lot of time for meetings, a lot of meetings which spring up fairly quickly, might be on a single bill, might be on multiple bills. So I would just recommend to you all to ensure that your staff are looking out for emails from myself or from Delegate Holmes as the chair. So that's just my little plug going into next week.
All right, so we are expecting additional amendments on 331 is what you said.
No, just to clarify, all of the amendments for 331 are what I sent out earlier. However, because of when we received them, I was not able to prepare them in advance of this meeting. So,
oh, I see.
Yes, I don't think it's appropriate to discuss them, but I am happy if during the week, anybody sees something, they have a question, please feel free to reach out to me.
All right. Okay. All right. So we'll do this for next week then. All right. HB 625.
HB 625. HB 625. This bill is the appraisal gap from historic redlining financial assistance program alterations bill. Bill makes various changes to the existing appraisal gap from historic redlining financial assistance program within DHCD. DHCD would be authorized to issue loans and other financial instruments. Financial assistance would be maybe provided to affordable housing developers working in sustainable communities. The bill would also repeal the requirement that on application by specified entities to the program, the department must provide financial assistance. Would repeal language that specified amounts for financial assistance and task DHCD with developing by regulation and application form and process for distribution of financial assistance under the program. So generally, overall, it makes a number of changes to the existing appraisal gap from historic redlining financial assistance program within the department. We've received some information from DHCD that in its current form, the program isn't frankly workable, but they had some available federal funds on hand to operate a pilot program in this manner. And so they found that pilot program worked, and they're hoping to try to amend the existing appraisal gap program to be consistent with the pilot program they had operated. I'd be happy to take any questions on the bill.
Are there
So
any
the
amendments
bill-
on this bill, Matthew?
There are no amendments on this bill.
Okay. Is there let's motion on the bill?
Second.
There's a motion favorable and a second. Any discussion on HB 625? Hearing no discussion on the bill unamended, if there's anyone in opposition of HB 625, let me know by virtual or physical hand. Hearing none, HB 625 will receive a favorable recommendation from the subcommittee. Let us now go to HB 639.
HB 639 is, okay, 1 second. It's restrictions on use, solar collector systems alteration. The bill would alter statutory provisions that prohibit unreasonable restrictions on land use related to the installation of solar collector systems under specified circumstances. Bill would specify that a restriction on use is unreasonable if application of the restriction to a particular proposal would increase the installation cost of the system by at least 5% over projected cost of the initially proposed installation, or reduce the energy generated by the solar collector system by at least 10% below the projected energy generated in the initial proposal. The bill would also establish certain powers of the community association with regard to installation of a solar collector system within the common area or elements of the development served by the association. There is one proposed amendment. However, it's taken a slightly different form than what was in testimony previously. I will pull up the proposed amendment now.
And these amendments are these from the sponsor or from stakeholders?
These are from stakeholders.
Has the sponsor had a chance to look at them? Do you know?
I'm unaware if the sponsor had a chance to look at these specific amendments. Perhaps some of the stakeholders who are participating in the amendment may be able to address that.
Broaden the screen a little bit, if you don't mind.
I'm trying to pull up the correct.
Ouch, okay.
Okay. So the issue had been, as some of the members on the committee may recall from the hearing, that under the existing language, there's a limited number of people who can provide the certifications as to what would constitute an unreasonable design in the state. What's under the bill currently, say, the documentation required under subparagraph I, so that's related to the set documentation of the restriction, that the restriction is unreasonable, shall be prepared by an independent solar panel design specialist who is certified by the North American Board of Certified Energy Practitioners and is licensed in the state. Sunrun, one of the companies who came out favorable with amendment on the bill, noted that there are only 2 of these individuals operating within the state, and I was able to confirm that. And so suggested an alternative, which is on the screen here. It would either be one of these individuals, an independent solar panel design specialist who is certified by the North American Board of Certified Energy Practitioners, or individual who has attested by affidavit to designing at least 50 solar collector systems in the course of trade. This, as I understand it, is consistent with one of the advocacy groups that was assisting the sponsor with the development of the bill. I also have a separate amendment to make, just something to suggest to the committee, but I will bring it up after discussing this.
Well, I took a look at the North American Board of Certified Energy Practitioners, and on the website, and for some reason, it seemed to me like there were quite a few persons from the state that did have the certification, unless I'm not going through the certification process.
These are the two individuals I was able to find for the design specialists. I don't have a zip code in there, but I mean, it's when you search by United States and Maryland and the specific role, it is these two individuals.
Okay. All right. Mr. Chairman.
Yeah. 50, saying that I made 50 of these. That seems like a very high number to me. 50?
I am not sure how the organization came to that. I just believe Grayson Wiggins is on the call. He's with CAI, and he was privy to that conversation.
Well, who came up with that language of 50?
This was the company Sunrun that came in favorable with amendment.
Oh, well, they're trying to get rid of competition. They're just trying to get rid of competition.
Yeah.
Well, I can't speak to that necessarily, but I would note that under the bill as currently drafted, there are only two individuals who would be able to, in the state, who would be able to actually do this type of work. And also there's an issue with language surrounding licensing.
Because there is no license requirement right now.
Right, there is no license.
They could just go down to Staples.
Yeah. and go down to Staples and say, I'm a PV installer. Yeah, okay. Delegate Boyce.
Thank you, Mr. Chair. And to the chairman's point, I mean, other than Mr. Council's technical amendment, is there a reason why we wouldn't move this bill? Because to me, okay, it's 2, but in a couple of years, it could be 4, it could be 6, it could be, I mean, that's right now, it's not,
To answer your question, the answer question is no, but that's why we're having the discussion. Yeah. Mr. Wiggins.
Thank you, Mr. Chair. I just want to, I'm here on behalf of CAI. We've been working very closely with the sponsor on the bill. I'm not sure that she's seen the amendment, but my client is okay with the amendment. Just want to put that on the record.
Okay. All right. So right now, we have no sponsor amendments on this bill.
No sponsor amendments. I'm not making an argument either way. I just wanted to point out to the subcommittee that this documentation requirement is a requirement under the bill to show to the satisfaction of a community association that the restriction is unreasonable. So if there is a restriction in place and it results in this effect, we need an individual looking to install solar would need this documentation, and the documentation must be under the bill prepared by an independent solar panel design specialist who's certified with North American Board of Certified Energy Practitioners. So it would effectively, at least in the short term, as Delegate Boyce pointed out, that the number of individuals could grow, limit who might be able to perform this work.
And it's very, in terms of the language in the bill right now, it would be very limited in terms of those that can perform under the language of the bill. And is that going to be problematic? I'm not, and I'm just discussing it here now. Is that going to be problematic? It probably will. Right, for right now. And I would just like to have that discussion with the subcommittee. We want to suggest to the sponsor to broaden the requirements that the installers have on this bill. Because if we leave it the way it is right now, there's not going to be anyone to perform the work that is being requested. And I don't want to kill the bill, nor do I want to put provisions in here that is not along the suggestions of the sponsor. Delegate Lehman.
Thank you, Mr. Chairman. Could somebody clarify the awareness, acquiescence by the bill sponsor around this language? If you mentioned that, I missed it.
I do not know, and that's why I'm having the discussion, because I'm not sure. I don't know if she is aware of how limited the language in the bill is per the requirements that she has put here.
And actually, not to confuse the issue, but frankly, the requirements under this bill are impossible as written, because this would also require the individual to be licensed in the state, and there is no licensing.
There's no licensing provision in the state at all right now.
So as I read it, there's nobody who can actually perform this work.
So Mr. Michael, are you saying that with or without that amendment that creates the problem?
I'm saying without the amendment.
Without the amendment, the way the language is in the bill right now, it is significantly problematic because A, there is no licensing structure in the state of Maryland. And B, based upon what Matthew just pulled up a little while ago, there are only 2 persons that are certified to perform this work. Mr. Chairman.
And just really quickly,
sorry.
Chair Holmes, we just realized that. How did this just came to light, like today?
Yeah, we're all busy.
I'm sorry?
We're all busy.
Okay, thank you.
Mr. Chair, if I could just very quickly, I think when I spoke to Matt, he just mentioned removing the provision about being licensed in the state, which my client is completely fine with as well. And the other quick amendment is the one he mentioned about the 50 affidavits, which we're fine with, which would just apply to number 1 here. And otherwise, I don't think there's any opposition to the bill.
Go ahead, Mr. Chairman.
Yeah, is certified by the North American Board of Certified Energy Practitioners. Do they have an exam? What do they do?
Yeah, there's an exam process. It's a I won't say a very lengthy process, but it is a process you have to go through to become certified. And to Delegate Boyce's point, it's 2 persons now. The number could increase.
Well, how many?
There's only 2.
Do we know how many states require this?
So this language was taken verbatim from Virginia. There are other states that also have similar language in their statutes. I believe New York is one as well.
I see Karen Strawn's on the Zoom. I mean, do we have a history of people getting bilked by solar installers?
We receive a lot of complaints about people being billed by people who are installing solar systems.
And I guess that's why the sponsor wanted to have the certification and the licensing requirements in there, but there, which kind of makes sense, but there is no licensing structure. Mr. Chairman?
Why don't we hold this bill? On the one hand, I think it's important to protect consumers, but on the other hand, I think we need to think about, we don't want to shut down this industry completely. There must be some other way. I would move to hold the bill. Great.
So that's 6:39. Moving on now to HB 833.
Okay. House Bill 833 would authorize the governing documents of a homeowners association to include a provision that prohibits a lot owner from voting at a meeting if the homeowners association has recorded a statement of lien on the lot owner's property and the amount necessary to release the lien has not been paid at the time of the meeting. That is, the language is actually meant to mirror language that currently exists for condominiums.
And are there any amendments on this bill, Matthew?
There are no amendments, sir.
Is there a motion or discussion on this bill?
Move the
No
bill.
favorable.
Is there a second? Is there a second? Yeah, Delegate Boyce is a second. Any discussion on HB 833? Anyone in opposition of the favorable motion on HB 833, raise your hand or digitally or physically. Seeing none, HB 833 will receive a favorable report from the subcommittee. Let's now go to HB 844.
Okay. House Bill 844. This bill requires the Department of Housing and Community Development to establish and maintain a website that provides information on the current rights and responsibilities of individuals living in a common ownership community. And DHCD must make certain information publicly available on that website. It would include a hyperlink to the website of each local COC program in the state or common ownership community program in the state, and information on statewide legislation enacted in the prior legislative session regarding the rights and responsibilities of individuals living in a common ownership community. Including for each bill enacted specified information and a hyperlink to the bill's information on the General Assembly website.
Any amendments on this bill, Matthew?
None from the sponsor, none that I've received in writing. There might have been amendments in testimony.
Okay.
Mr. Chairman, I'll move favorable.
Is there a second on HB 844?
Second.
Is there any discussion on HB 844? If anyone is in opposition of 844, raise your hand, let me know. Seeing none, HB 844 will receive a favorable report from the Housing and Real Property Subcommittee.
I'm sorry, Mr. Subcommittee, Mr.
I'm
Chair.
sorry?
I had actually a question. I was looking at the realtors. They were favorable, but they were asking about well,
Well, we voted.
well, well,
Right. I'm sorry, Delegate Boyce. I didn't mean to go too fast. I'm sorry. I apologize. I'm sorry. Delegate Naricki.
I had the same question, Mr. Chair, but the delegate voice had, but we already moved on.
I'm so sorry. I'm so sorry.
It's okay.
That concludes the work. I'm sorry.
I was gonna say there's always the full committee voting session.
Full committee, that's correct. That's correct. That's correct. Thank you, ladies and gentlemen. We've gone through 10 bills this evening. I appreciate your cooperation. There is more to come. So stay tuned.
thank you, Mr. Chair, for your leadership, and thank you, Mr. Chair, for hanging out with us.
Mr. Chair.
I like that.
Chair.
It's like pop, right?
Big chair, little chair, big chair, little chair.
I'll take that. See you guys later.